Good afternoon, and may I please the court. My name is Bart Malcom, and I represent Pepsi in this matter. Your Honor, I am making a motion under Federal Rule of Civil Procedure 60B1 to set aside a default judgment entered against my client Pepsi on September 30th of this year. Now, this court has the authority under Federal Rule of Civil Procedure 55C to grant our motion to dismiss. Also, under Federal Rule of Civil Procedure 60C, it is suggested that we make this motion within 1 year, and as you know, we're within 1 week. Now, a motion to dismiss can be granted under 60B1 if there was a mistake, if there was an inadvertence, if there was a surprise, or if there was excusable neglect that led to the failure of timely responding to a complaint. Now, this court stated in Rogers v. Hartford Life and Accident Insurance Company that it adopted a policy to resolve cases on their merit and really against the use of default judgments. Now, this court also in Rogers stated 3 factors that it would use to determine whether sufficient grounds had been met to set aside a default judgment. Now, the first factor that this court said was the prejudice against the plaintiff. Now, it is possible that if this case proceeds on the merits, that the plaintiff will lose its judgment. However, this court also stated that a lost judgment is not sufficient grounds to deny a motion to dismiss. Second factor. This court stated that it would measure the merits of the defense that we may assert in a case if it proceeds. Your Honor, it's been 28 years since that meeting, and it's been 15 years since Aquafina, the entity that allegedly has harmed the plaintiff, was established. So the timeliness of this complaint is really interesting, as well as we feel that we can show that there were no NDAs or any other types of documents or agreements in place that would reflect that our client violated anything. Regardless, we feel that we have sufficient defenses to allow this case to proceed on its merits. Third, culpability of the defendant. Now, Your Honor, my client was served in North Carolina and not in New York. New York is his principal place of business. By serving in North Carolina, we feel that the plaintiff did not provide proper service under Rule 4E1 or 4H1B. Regardless, though, the fine folks in our North Carolina offices forwarded the complaint to New York, and when it was received in New York, our secretary there, who was very busy working on a board meeting, which, by the way, is required to occur given that Pepsi is a public entity. Regardless, she was busy preparing for the board meeting, set the documents aside, and once she realized what was she had, then they proceeded to respond to the complaint. Now, Your Honor, there was no intent to thwart judicial proceedings or reckless conduct or reckless disregard for judicial proceedings in this case. Your Honor, we can't say that there was not neglect, but it was excusable neglect. And because we feel that we've met the 3 factors, we feel that the motion to dismiss should be granted. Thank you.